Hi, this is Alan Gassman, and I am here with two of the most brilliant and insightful presenters in the world, Marty Schenkman and Jonathan Blockmacher.
I wish you could have said good looking, Alan. I would have been so much happier.
That I couldn't do. Well, the deer looks pretty good there behind Jonathan. These two brilliant planners are going to tell us about planning in an uncertain environment, which we certainly have here. I've been looking at these slides, honestly, for a couple of hours, and there's a lot to cover. So we're going to get right to it. Send us your questions and we'll get them answered. And thanks so much for attending this.
Can you see the slides?
Yep.
Can you see them advancing?
Yes.
Yep. I would add to the general disclaimer that we normally say that, boy, is there a lot of uncertainty. It is really, we really don't know. Alan, you want to tell people how to ask a question?
If you have a question, go to the rectangle. If you don't see the rectangle, click on the little red arrow, and then you will see the questions panel. Click on the upside down pyramid, and then you can type in your question and we will see it. And if we know the answer, we'll answer it. If we don't know the answer, we'll pretend we didn't see it.
So we'll get back to you. We'll get back to you in all events.
So all jesting aside, the environment we're in is incredibly uncertain, but this is not, for us as estate planners, a unique or new thing. The types of uncertainty may be different. We'll talk about them, and I think you already know what they are. But we seem to constantly live in an uncertain environment. And what we're going to present are ideas, options for planning and drafting in light of the uncertainty. Uncertainty shouldn't mean that planning stops. It means it should evolve and become more flexible to deal with the uncertainty. I mean, right now, the uncertainties go way beyond just tax law. We face incredible uncertainties over the tariff, stock market, the state of the world. There's lots of uncertainty. From a tax perspective, while it seems highly unlikely, almost, I hate to say zero, but near zero potential for an estate tax increase of the likes that have been talked about for years. We don't know whether or not the 2017 Tax Act reductions will be extended, including the bonus exemption. We know that the Republicans want to extend it, and they may have sufficient votes to do that. They've talked not only about extending it, but about making it permanent. And there's also been proposals to repeal the entire estate tax. So, that's a pretty broad continuum of possibilities. And what do? And it seems to me, and Alan, Jonathan, interrupt me, I don't want to talk too much, but one of the general messages to all of us as estate planners is that we shouldn't be focused only on taxes. We know that, but yet for several years now, the conversations with clients have seemingly centered around, in many cases, you got to plan before 2026 to use the exemption because it's going to decline. That doesn't look like a great likelihood of occurring. So talking about the myriad of different human aspects of planning, from aging population, health issues, addiction and mental health issues, elder abuse, and so on, asset protection, income tax planning, which are not really are the focus of our discussion today, but all these other non-estate tax aspects of planning certainly deserve more conversation. And just very quickly, because again, it's not our topic, but since we're sort of introducing this discussion of what to do today, with a quick look at the planning environment, AI is going to transform everything. It's transforming everything now. Financial advisors are taking a much increased role in estate planning, and over the coming years, we should all anticipate that they will be far more important and far more involved in every aspect of estate planning.
But Marty, let me mention, for those who didn't see it, it was on 60 Minutes, there was a segment about artificial general intelligence. And it revolved around a guy who's in charge of that for Google. And he not only has won a a Nobel Prize for his work in that area. He's also been knighted by the Queen. He happens to be British, but it was fascinating. And he says, and I believe this to my soul, that within 5 years, everything will be different. The way we practice, the way we do things, what we care about will be different in 5 years. It's the kind of thing, and I think he gave an analogy to it, it's like the development of fire or the wheel to human beings. So keep that in mind. But flexibility right now is the #1 thing to shoot for. We don't know what's going to happen from a tax perspective. Heck, we don't even know what's going to happen from a legal perspective. I mean, if they really extend longevity, and this guy last night was saying he thinks that the concept of eliminating disease is actually on the table and will occur within 5 or 10 years. Now, you can imagine what that means. You won't have to worry about the rule against perpetuities anymore because people just aren't going to die. I know that's a little off topic, but it's something to keep in mind, and it's coming on very, very quickly.
And we all have to adapt to it. And those will be discussed on other programs, or were discussed on other programs. But I think the key point is we're going to talk and focus in this program on what you can do now for clients in light of estate tax uncertainty. But as Jonathan and I said, it's far greater, far broader than just whether or not the bonus exemption is going to be extended. Alan, I just put this in for a little perspective. I don't know what percentage of people, focus only on, very high net worth clients, but for the bulk of estate planners, the exemption at a $14 million level where it is now has really reduced the number of people that pay or consider or worry about an estate tax to a very small number. And I just, from a practical perspective, I don't know that the estate tax really affects that many people. Certainly for everyone on this call, it's probably a large portion, if not all of their clients. But for practitioners in general, it's just not the relevant factor it was when we had a much smaller exemption. Any comments or thoughts?
I've had 2 clients in the last 2 business days tell me that they're going to do estate tax planning, even if the exemption goes to infinity, even if there is no estate tax, because they think it's coming back, and they think it's coming back at $3.5 million. So a big question is to say to the client, do you think if the estate tax is gone, it's coming back? Do you think if the exemption goes up, it's coming back down? And if so, what are we going to do about it?
I can't find clients like that, but I think they're right. First of all, and that's part of the uncertainty. When we're talking, and Jonathan mentioned rule against perpetuities, right? Long time. If we're doing estate planning, it's absurd to assume that whatever law is today, or whatever the Republicans change it to, is going to remain what the law is going to be for the next, remainder of the client's life, especially given how life may be extended, as Jonathan said. If the Democrats sweep in 2028 or 2032, and if not 2036, we may very well have, something analogous to a Bernie Sanders estate tax and an Elizabeth Warren wealth tax as well. So I think Alan's clients are spot on. I just don't seem to meet people that want to take that long view. But that, to me, is the ultimate view. And that's why I think it's so important that clients plan. And oh, by the way, in plan, you got asset protection, you got divorce protection. There's so many benefits to planning, and who knows what the law is going to be down the road.
Let me also add that a client, say, has $5 million today. And she says, even if they cut it down to 7 million, it's going to continue to grow with inflation. I'm never going to have an estate tax problem. And maybe she won't. Maybe, she'll wind up spending all her money. But remember that the value of things goes up. Since I got out of law school in 1970, Alan, guess how much the inflation has grown since 1970? In other words, what I could buy with $1 in 1970, how many dollars do I need to buy that same product today? It's $10. It's $10.
Wow.
Think about that. 10 times more. So the fact that you have this big exemption, maybe it's going to be cut in half, it's going to be eroded in time, even though it's adjusted for inflation. The way the government calculates inflation doesn't really take it into account. So if you really want to protect yourself and your family, you've got to do your planning as early as possible. Yes, you want flexibility, things will change, but you want to do planning now, even if you've only got 2 million or 6 million. Because remember, even at only a 7% return, which probably is not as good as many advisors can get you, your money will double in 10 years. It will quadruple. It will be worth 4 times more in 20 years. And it will be worth 8 times more in 30 years. So if you have a 55-year-old and you think, well, she'll probably live to 85, she's going to have 8 times more wealth merely if she gets just standard returns. So you've got to urge your clients to do planning with a lot of flexibility.
So Jonathan, a Happy Meal was a dime when you were in graduate?
Well, believe it or not, a Happy Meal wasn't a dime. I don't think you can get a Happy Meal for $1 today, Marty.
No, I think it's 5, isn't it?
Yeah, but it was I remember when I was first married in 1970, we could go out and get like the equivalent of a Big Mac today for about $1. It was less than $1, and that was with French fries. But today, come on, give me a break. I mean, when you think about that, think about a car that you could buy, for $3,000. That was kind of a low-end car in 1970. Now that car you couldn't buy for $30,000. It's gone up tenfold at least. And again, the government tends to understate what inflation has really been, because they say, well, what we'll do is we'll assume that people will substitute lower quality goods. So if you like steak, forget it, you're going to eat chicken. And if you like something else, it's going to happen. This is one other thing I want to mention, and that's what I call inflation expectation. When I got out of law school, I mean, my wife and I had never been to Europe, although Bessie had been an exchange student for a while. But the thought of going on vacation as a young lawyer, even though I worked for a big Wall Street law firm, who could afford to go to Europe for a vacation? And now a secretary goes to Europe, Hawaii for Christmas, and so on and so forth. Everybody thinks that their lifestyle has to be better than the people before them, and that is going to continue. All the toys and whistles and things we had, who could live today without an iPhone? Something that didn't exist. In fact, I remember there was a show on TV, probably Alan, you and Marty are too young, but there was once a show on TV called Star Trek. And in Star Trek, when they go to a planet, they had a little thing on their waist that they would pull out and they would flip it open and they could talk to people in the ship. Absolutely preposterous. It would never happen. So keep in mind, it's all going to change and it's going to come on so much more rapidly. Let me just point out a couple of things. Pope Francis recently died, and he was the head of the Catholic Church, the Christian Church. And Christ died about 2,000 years ago. And at that time, believe it or not, human knowledge was increasing. And it was increasing at a rate that it would double every 1,000 years. Well, by 1900, we knew so much more at 1900. And you think about in 1900, there weren't planes, there really weren't phones. And you think about the way things are now. Doubling in 1900 rather than every 1,000 years. By the end of World War II, 45 years later, human knowledge was doubling every 25 years. Now human knowledge doubles every day, and it continues to accelerate. So again, stay on our toes, keep ahead of the change curve. That's important. Sorry with that message, guys, but I think it's important for us to accept the fact that changes are coming that we can't even foresee.
Jonathan, you and I did a webinar in 2020, and I came across the slide from that webinar, and I just posted it here to just show that the uncertainty that we face now, we've been dealing with this for a long time. right? We were worried in 2020 about Democratic tax proposals that would have made the estate tax much harsher and planning for that. But the uncertainty may be different, but it's still uncertainty nonetheless. Alan kind of already said this, and just to repeat very quickly, not to belabor it, for certainly ultra wealthy clients, they should plan for the long term. And like we said, you may have a reinstatement of an estate tax, even if it's fully repealed. We could have a wealth tax. We can't guarantee, and this is something we're going to very specifically talk about. So if very wealthy clients want to plan to shift assets into long-term or perpetual trusts outside of their estate, that to me still seems like a sensible approach from an estate protection, asset protection perspective. It gives you more flexibility when the trust becomes a non-grantor trust to shift income to lower bracket taxpayers. And we'll talk briefly about that. But one of the new issues that I don't recall people thinking about in the same way we do now, right now, is that if we make large wealth transfers to trust, what if they repeal the estate tax, but leave in place the basis step up on death? That may or may not happen. But if that's the scenario that occurs and the client dies having moved those assets to an irrevocable trust, may keep them out of the estate, but there's no estate tax savings if the estate tax is repealed, and all they'll do is lose the basis step up. So that's one of the slices of uncertainty, and we're going to talk about that. Now, Jonathan Allen, if you want to take over, the next segment talks about 5 different planning approaches to deal with the uncertainty about what will happen. In general, we're focusing on whether the exemption stays the same or declines as it's scheduled to do in 2026, but giving clients planning flexibility to unravel or unwind planning. Alan, do you want to go through some of these?
Marty, you go ahead and lead them. You're doing
So,
well.
so there's five different approaches that we're going to talk about in this segment, and then we have other segments talking about other aspects of flexibility. So one approach is a standby trust. We'll explain that. Another approach, which we've talked about in prior years when there's been similar uncertainty, is a QTIPable trust. We've talked about years ago using a disclaimer provision in trust to unwind planning. Rescission may be a feasible tool. There's income tax law on rescission. Maybe it can be applied in a gift tax context. And similar to the standby trust is setting up a revocable trust that can be revoked. So these are just 5 techniques to have in your toolkit for this uncertain. So step 1, or planning technique 1, we don't know what's going to happen, and we also don't know when it's going to happen. So for a client to say, listen, I'll wait and see, we all know that waiting and seeing may be analogous to you snooze, you lose, because if the client wants to wait and see, there may not be enough time to react. So one planning idea, and yeah, clients are adverse to paying money for a trust they may or may not use, but relative to the wealth involved and the transfers that may be contemplated, creating a trust today so the client can methodically think through what they're doing. We can talk to the client about a lot of the different techniques here. Getting the trust in place, maybe put $1,000 or $100 in the trust to open a bank account so you have a real functioning trust that can be the receptacle for a quick transfer, may in fact be a prudent way to deal with the uncertainty. So a client says, you know, if they can't get the exemption extended, I want to make sure I use my exemption. Well, waiting to see may not give enough time to react. Why not get the trust in place? And you can go a step further and have transfer documents created now. So for example, if the client just has to ACAT securities, if you set up an account with $100 or $1,000, you now have an account set up. All they have to do to fund it is ACAT securities in. But if there's private equity, LLC membership interest, do the assignments now. Just don't have the client sign them. So you can have the trust in place with a nominal funding. You can have assignment documents unsigned in place, and literally at a moment's notice, the client can pull the trigger and execute the plan. if you go through that,
Marty, just let me mention, one of the ways that I've done this in the past is you have exactly what you want, except that the client retains the power to revoke it. But the client loses the power to revoke it by a notification to the trustee. That means everything's done, everything is transferred on a temporary basis, and it never will be complete for estate and gift tax purposes unless that power to revoke is expunged, either by death or by an affirmative action by the power holder. So that's something you can really do. If the client says, yeah, I like this, but I really don't want it to happen if the law isn't adversely changed, or maybe even if I do it and I think it's good, I may want to undo it. So you've got to keep all of those possibilities in mind.
and that is in fact the fifth of the 5 techniques that we're talking about in this section. So we've now covered that. Let me just make one other comment that may be helpful. So if a client wants to set up a transfer of private equity interest in an LLC that owns a building, and they got the trust set up, and now it comes time that we have a very short window to act, and they want to make the transfer. One of the things you might think about in that context and build into the assignment is what I'll call, for lack of a better term, a 2-tier wandry or 2-tier adjustment mechanism. Normally in a wandry, you transfer, let's say for argument's sake, $10 million worth of LLC interest. And then if the gift tax value is finally determined is different than more than 10,000, the membership interests are 10 million, the membership, thank you, are adjusted. The 2-tier approach is tier 1 is you make a transfer now, but you don't have time to get an appraisal. So the first adjustment is when we get a qualified appraisal, we're going to adjust the estimated membership interests from 10 million to whatever the appraisal says that it is. The second adjustment is your standard or typical wandry or king type adjustment. And that may be useful in this type of planning. Jonathan, you want to explain the QTIPable trust plan?
Yeah, this is, if you have a spouse who is a US citizen, you can create a QTIP type trust for your spouse. You can make it, completely irrevocable so the transfer is complete. But it will not qualify for the marital deduction unless and until a timely QTIP election is made on the gift tax return. And if you decide, I really don't want the transfer to occur and your spouse is going to cooperate, you make the QTIP election. It's now going to all qualify automatically for the marital deduction. And then the trustee of that trust could go ahead and terminate the trust, give it over to the spouse, who could return it to the grantor spouse. Now, this assumes you've got a very healthy, perhaps first marriage situation where the clients feel comfortable. I wouldn't do this for each other because you get into the reciprocal trust doctrine, perhaps. But keep in mind, in order to make a QTIP election, it has to be on a timely filed gift tax return. There are literally hundreds of situations where the IRS has allowed people to make late QTIP elections for estate tax purposes, but you cannot make a late election for gift tax purposes. That means you're probably going to want to go on extension. So if you make the gift, say today, you could wait until September of 2026 to make your QTIP election or not. But don't fail to either make it if you want it. If you don't make it, it will not happen. And you're going to have the assets qualifying or not qualifying for the marital deduction, and you will use exemption.
Just a thought. If the estate planner is doing the planning for this QTIPable trust and the transfer, and an accountant for the client is going to draft the gift tax or prepare the gift tax return, make sure that you as the estate planner communicate directly with the accountant. Don't rely on the client, and make sure the accountant has this point on their radar so that it's not overlooked. Because as Jonathan said, there's no backsies if you don't get the return filed.
Yeah, it's just so important, and I've seen this happen in the real world. And people become very, very upset that they thought that, okay, we're going to Q-tip this property and I'll get it back. Well, if you haven't filed the gift tax return and made the election on a timely basis, which, that would be, if you did it now, it would be April 15 of 2026. And if you go on extension, you'd have until September. Don't forget to do it. It's critically important. And very often, as Marty was indicating, you may not have great communication among the client, the lawyer, and the accountant. And you can bet that if there is something gone awry, everyone will be blamed other than the client.
So that's another technique. The disclaimer approach is yet another one. So one of the issues that we have is client says, listen, if the exemption, the bonus exemption is not extended, I definitely want a plan. And by the way, what we're going to talk about in one of the upcoming segments is if the estate tax is repealed, people may want to have transfers done before the estate tax is repealed, because how do you allocate GST exemption if there's no estate tax? And whether or not that will safeguard them and grandfather them should the Democrats sweep in a future election and reinstate it, we don't know. That's certainly a thought to think about. But there's a called a disclaimer that you all know about, 2518. You have a disclaimer, and if a disclaimer is exercised, it's as if the assets never passed to the recipient. In this context, it's slightly
Marty,
different because what?
Let me add here. It's so you don't have to do it. You don't even have to tell the IRS. In other words, you don't have to file anything with the IRS saying, oh, by the way, we made this transfer, but it's been disclaimed and it's gone back to the grantor, for example. So keep in mind that if you do file a qualified disclaimer, it's just treated as though it's never happened. Now, if you get into a trust situation, it may be more complicated. And Marty, why don't you talk about that?
So the concept here is I make a gift to a grantor SLAT, and I'm not sure if I want all those assets passed into the SLAT or not because the world is so uncertain. So I give my oldest son, Jonathan, not this Jonathan, my Jonathan, the authority to disclaim. But unlike a typical disclaimer where if he disclaims then it passes as if he predeceased, this type of disclaimer provides that if my son, eldest son, disclaims, the assets pass out of the trust never accepted them, and they revert to me. So it's not that he's just disclaiming on behalf of himself, he's disclaiming on behalf of the entirety of the trust. And that can be drafted contractually right into the trust instrument. So you can give the ability for this disclaimer and give 9 months from the date of the transfer to unwind the transfer. Now, some people have raised questions whether or not this is viable and works. And first point, let the client make a decision. If it's important to the client that they want the ability to unwind the transfer, they can make the decision to accept the risk whether or not this technique works. Another comment. One of the complaints that I've heard about this technique from people is, well, gee, if it's a pot or sprinkle trust, how can one person disclaim? Well, I think legally, contractually, you can put any terms you want in the document. Why wouldn't they govern? A trust is a contract. But there's another simple approach if the client is worried about that issue, and that is I can have an initial trust for the first year, 2, 3, whatever, that my son is the only beneficiary of the trust for that period of time. So that if the assets are in that trust for X number of years and he disclaims, he's the sole beneficiary. And then after 1 year, 2 years, 3 years, whatever I said, it can pass into the pot trust. So that's another approach that can be used to try to deflect one of the concerns that people have. But one of the comments that I think is important is I think it's important for practitioners to think about or try to give options like these to clients because of the incredible uncertainty. I also like the idea of building in this disclaimer provision, and Alan, you may want to comment, because there's just so much uncertainty in the world right now. If I give the client an ability, even if it is subject to some uncertainty, to unravel the whole transaction, I think the clients will be very comfortable with that. I think that will make them feel more comfortable going forward with the planning. I also think that if circumstances change, the client can unravel the planning. And if the client has 9 months to go back and unwind the transfer, I don't think they have a right to then complain to the attorney, gee, you pushed me to do this. Even if I did, which I didn't, because I don't know anyone that pushes. We don't get bonuses by clients doing planning. You know, we're just trying to help them. But listen, you had 9 months after you made the transfer to unwind it. If you chose not to unwind it, don't fault me for you making a transfer that now, with hindsight, didn't look good. You had a chance to unwind it. So I kind of like the idea of including this. But sort of the theme of a lot of this is giving clients options and building in flexibility into the trust document and the plan to address it. Rescission, I don't think we should belabor because I think there's more important points. There's some material here and some sample language on rescission. And the point of rescission, or the idea very simply, is under the income tax laws, if you unwind a transfer in the same tax year and put the taxpayers back to the position they were in, the transaction is as if it did not happen. Can that apply in the gift tax context? Not certain, but it's, if you need an idea, maybe it works. It's just something else to have in your bag of tricks. Jonathan, do you want to say anything about rescission, or I don't think we want to belabor because we have a lot more important stuff.
Let me say the IRS has approved rescission, but it's only approved it in the income tax context. In other words, if you do a transaction and then the parties rescind it and they do it within the taxable period you're dealing with, the IRS says we'll treat it as though it never happened. That's somewhat different perhaps than in the gift or estate tax context. So if you want to do it, I would rely on qualified disclaimers. I think Marty is absolutely right that you can create a trust and say, you know, my son Alan is going to be the beneficiary for the first year, and if Alan renounces under Section 2518, the property will revert back to the grantor. And again, you don't even have to report that to the Internal Revenue Service. There's no mechanism in Section 2518 or the regs under 2518 which says you've got to tell the IRS about it. It just doesn't count. It's treated as though it never occurred. Keep in mind, it's got to be done within 9 months of the transfer. Rescission, theoretically, you've got the entire taxable period. So if you did something in January, you'd have until the end of December. But again, the cases on it and the revenue ruling that approved it deal with income taxes, not estate and gift taxes.
It's actually, just very quickly, a little harsher than that, because one of the, I don't remember which, but it's in the materials. There was a change in zoning, or zoning couldn't get through, so it was an external event, which is why they unwound the transfer. So different than a gift tax context. But again, if there's a real difficulty, it's at least something to have to bring up to a client as a possibility to explore, even if there are risks or issues with it. So, Jonathan Allen, one of the real critical changing gears now, we've talked about some mechanisms and techniques that can be used to unwind a transfer for clients that aren't sure if they really want to do it depending on what happens. We talked about the importance of the long view for wealthy clients, and I agree with that. But we also want to infuse flexibility beyond just unwinding a transaction because of the incredible uncertainty. And Alan, I wish I had clients that were as smart as your clients that realized that they got to plan for the long term, because who knows how many times the law is going to change again. So what about powers of appointment, Alan? You want to talk for a minute about that?
Yes, so the ability to give someone, or a group of people even, a power to redirect trust assets, a power to set up a new trust and transfer the assets into that new trust, gives you an immense playing field, as long as you can trust the person who you give the power of appointment to. And you can make it a very, very broad power. as long as they can't appoint it to themselves or their creditors or their estates or creditors of their estate, they may see fit to do anything that the grantor might request that they do over a long lifetime. So it's a brilliant idea that Jonathan's had and that you guys have shared to have, you know, that type of a power of appointment involved in an irrevocable trust. It's something that people just don't think about. And it doesn't have to be held by the primary beneficiary. It can be held by a very wise family member who may use it, you know, in a very
That is true. And one of the things that you can do to, you know, you say, you know, Marty says, I trust my son Jonathan, I'm going to give him this power, and, you know, he'll redirect it the way I want to, or Marty hopes he will. But I can tell you that over time, Marty's relationship with his son will change. And what you want to take into account is that Marty's son, Jonathan, should be able to exercise that power only, I'll call it, with adult supervision. In other words, if he wants to do it, he'd have to go to Marty's lawyer or his rabbi or someone else who Marty reposes trust in to make sure that it's not exercised in what Marty would believe is an inappropriate way.
That's Alan. Alan's my guy.
But so in other words, Jonathan, you would give this power of appointment to my sister. If my sister can't use it, then my niece, but only with the approval of one or more people in the following list. So that there would be fail-safe if somebody came in and tried to take advantage.
Right, because, you know, someone might, you know, prey on some family member who has the power of appointment, and they're going to have to go to, you know, it might be any two partners or three partners of your law firm, Alan, or the successor firm or something like that. That way, it's going to be a thoughtful decision. It's not going to be a knee-jerk decision. And I think you're really protecting the family a lot that way. In fact, I've always been a fan of powers of appointment, but as I became older, even when I was giving the children to appoint it among their own descendants, you say, well, that can't be bad. Well, but maybe, you know, my son decides that he's going to exercise it in an unhealthy way, I'll call it, or a bad way, or a mean way. So all he has to do is go to the trustee, and the trustee can say, no, that exercise is perfectly okay with me. I think that would be consistent with what your mother or father or grandparent, whatever, whoever it is, gave the power. It would be consistent with them.
So one of the things that I think we're kind of proposing now, it's been common for a long time to include limited powers of appointment in testamentary trusts and trusts, so that if I have a trust, whether I form it during my life or a death for my child by will can exercise a limited power to appoint among his descendants, as Jonathan just explained. I like the idea of the guardrails that we were talking about. I think what we're suggesting today, because of the incredible uncertainty and the potential desire to unravel a plan that may not make sense because we can't predict where the law is going, you may want to give lifetime powers of appointment that you may not have given before, just to infuse even greater flexibility into the trust. But as we've cautioned, you know, they come with that little, you know, warning on the label of the aspirin, right? You know, be very careful because these powers are powerful. That's why they're called powers, and they may be exercised in a way that you don't like. So as long as clients understand that it gives great flexibility, but there is a risk, and you can moderate that risk with a monitor or guardrails like Jonathan described. But I think we want to incorporate more powers of appointment as clients are worried about having more flexibility. That's part of the answer. And we're going to talk about SPATs in a minute, because I think that could be an interesting application of this, specifically in light of the types of uncertainty that we have now. Jonathan, Allen, what about giving, I think using trust protectors has been becoming routine in complex trusts, and sometimes people even put protector-like provisions in wills. We'll call it an estate protector for lack of a better term. But the question is, what do you think about giving more powers to a protector to try to recreate or correct the tax consequences back to what they were intended to be at the time that the decedent died, or that or before death, or in case the decedent's incapacitated before death, or really in the context of a trust, to put the tax result as close as possible back to what it was intended to be when the trust was funded. Thoughts, comments?
Well, Marty, more flexibility is great, but if it's done in a will, I think you have to be worried, number one, about if you wanted something to qualify for the marital deduction and someone can change that so it wouldn't qualify, I don't think you get the marital deduction, whether or not that power is exercised. It's the possibility of taking the rights away from the spouse that I think kind of sinks the ship. Similarly, you may have GST issues there. So before you put it in a will and say, oh, here's my disposition, but you can change it if you want to, think about the consequences of what would happen, because normally you just take a snapshot as of the time of the property owner's death, see where the property is going, and that will determine the tax effect. It may also affect the rule against perpetuity. So once it's in trust, I think you can have a lot more flexibility granted to a protector than in a will itself, as opposed to a trust under a will.
How do you feel about giving the trust protector the authority to modify the trust to establish as close as possible the tax intent when the trust was created? In other words, going beyond some of the typical powers given to a trust protector to remove, replace, change situs, etc., because of the incredible uncertainty in the tax law. Maybe a power of appointment will fix it, but if it doesn't, this is perhaps another backstop.
Well, Marty, I think that's a good idea for a long, long time, because I have learned through the decades that I've been practicing, I can never draft perfectly. So I very often use what I call an expression of intent. I intend this trust to qualify for the estate tax marital deduction, and I direct that this instrument shall be construed and the trust administered to carry out that intent. Throughout the United States, one of the most famous cases is one called Fabry, decided by the New York Court of Appeals, its highest court in the 1950s. And there's even a tax case called In Re Reid, R-E-I-D, where the court said, once we ascertain the property owner's intent, we must construe the instrument to carry out that intent, even if it's to change negatives to positives or positive to negative, even if it's to delete pages or add paragraphs. So if you're not certain as to whether or not your drafting gets exactly where you want it to be, please consider an expression of intent. And I put that in almost all of my documents. I want this to qualify for the marital deduction. I want this to be a good charitable remainder trust under section 664 of the code, and so on. I mean, it's just a great thing to do, because that tired old judge who will be reading it, and you split an infinitive here, you didn't do this there, you forgot to put a comma in. If you say what you intend, that should rule the roost at the end of the day.
I think this gets even harder because in your examples, which I agree with fully, of qualifying something for a marital or a charitable deduction, we have no idea what's coming down the pike in terms of estate tax. We could have estate tax repeal, which is pretty extreme to say the least. So it could get a little harder. I've drafted, and I'm not saying they're even reasonably good, but I've given you some suggestions on slide 24 and 25 just to get people started with what they might want to look at, and I'd love to hear anyone's comments on what they think. Changing gears slightly, one of the issues is with marital trusts is if assets go into a marital trust, the idea is to get a basis step up on the second death. Are we assured that's going to happen? What do we do? What are some of the worries? What happens if the estate tax is repealed and assets are in a QTIP trust? If section 2044 is not there because the estate tax has been repealed, we may not get the anticipated basis step up on a marital trust. So we may need to get the assets out of the marital trust to the surviving spouse's personal name in order to get the basis step up. Thoughts, comments?
Well, it's very hard to know, Marty, because, you know, there are ways in which you can get an asset in the client's estate. For example, you can perhaps grant them a general power of appointment. And in some states like Alaska, having a general power of appointment doesn't cause those assets to be subject to the claims of the power holders' creditors. In almost all states, if you have a general power of appointment, it's subject to the claims of your creditors. But in Alaska, the answer is no. It's only to the extent it's actually exercised in favor of the power holder. So that's something to consider. You also have the Delaware tax trap, which is something that I developed in 1988, that long ago, when you guys were still in grammar school, Marty and Alan, with Professor Jeff Bennell, where you can basically have someone exercise a power of appointment and cause it to be in the estate as though it were a general power of appointment. So there's lots of things that can be done to bring it in the estate, but thinking it through carefully at the beginning is what you want.
And I think, go on, Alan.
Having that trust protector with the power to add powers of appointment is very nice to have. Very nice to have. Otherwise, you may have to go to court and ask for that. But if the Republicans are strong enough to eliminate the estate tax, they're probably strong enough to make sure that surviving spouses with QTIPs get a step up. We'll see.
Again, more uncertainty. I think you may want to at least discuss with the client going further, because the things that we've just talked about, like powers of appointment, we don't know the impact if the estate tax is repealed. So even if, for example, you gave a general power of appointment to the surviving spouse and state law didn't make that at risk to creditors, that sounds like a good solution. But if there's no estate tax, the provisions that cause estate inclusion from a GPOA may not do any good for you. So you may want to have a provision that permits distribution of the QTIP assets. And I guess if the estate tax is repealed, we don't have to worry about 2519 because that's gone too. But at least permit distribution for tax planning purposes, so it's contemplated in the instrument. And if the estate tax is repealed and the surviving spouse is on his or her deathbed, you may want to actually distribute those assets pursuant to that right, simply to get them into the surviving spouse's estate, because that may be the only way to secure the step up.
Well, keep in mind that giving things outright to people can be very far reaching. For example, there may already be a creditor on the scene. For example, you know, the tremendous number of people who go through a divorce, or maybe you want someone to be able to qualify for government benefits like Medicare or Medicaid, and all of a sudden you're going to be blocked because, you know, you've got a power to, where that person has a power to have the assets go elsewhere. So you've got to be very, very cautious on doing these things. And it takes a lot of thought about what things could happen.
Well, John, in this environment where maybe estate tax repeal is possible, would you add something to do more than just the GPOA, LPOA that can convert to GPOA planning? Would you permit a distribution either by the trustee or by the trustee with consent of the corpus of the trust? How else can you get it into the surviving spouse's name for a step up?
Well, again, under current law, if you have it in the right place and you do it the right way, you can use the Delaware tax trap to actually get it in the estate. I mean, section 2041A3, and there's a comparable provision under section 2514, which says, if you give the beneficiary, and as Alan said, you can give it later, to the beneficiary, and the beneficiary exercises it in a manner basically to start a new rule against perpetuities period without regard to when the original trust was created, then you basically cause that special power to be treated as a general power. And I mean, that's something you can do. You don't expose it to claims of creditors. And in Alaska, even if you give someone a general power to trigger the trap, it will not cause the assets to be subject to that particular person's creditor claims. keep in mind that it is the law that governs the trust which determines it. There's a very famous case called In re Remington, where the bankruptcy courts of the United States said that whether or not assets are going to be subject to claims of creditors, these are assets in trust, depends upon the law that governs the trust. So if you want to use this technique, you might consider starting in Alaska. I realize I push Alaska a lot. That's because it was actually a lot easier for me to get things through with my brethren there than to get things in New York or other states.
So let's consider another approach. Again, all the planning you're talking about, if the estate tax is not repealed, the exemption is just the bonus exemption, may be extended, may be made permanent, all those techniques work. The question becomes, if they actually repeal the estate tax, how do we get assets to get a basis step up if that remains the law? So what about the idea of building a SPAT, special power of appointment trust provision, into the trusts that we create? So Alan creates a slat for Marcia, his wife, puts, a large transfer into that slat, but gives you, Jonathan, independent, unrelated party, a special power of appointment, a limited special power of appointment where you can, in effect, tell the trustee, make a distribution to Alan. You now have the legal right to tell the trustee, give those, 6 highly appreciated assets back to Alan. So if Alan is, in harm's way, those assets could be physically moved back to his estate. And it seems to me that that transfer has nothing to do with the status of the estate tax rules, because it's independent of the estate tax rules. So that may be a way that even if the estate tax is repealed and the inclusion rules, the GPOA rules for estate inclusion are eliminated, you can physically get the assets out to Alan.
Yeah, Marty, I think that that's right. Again, this is called a special power of appointment trust, or SPAT. And unlike the normal asset protection trust, which I will take maybe primary credit for getting domestic asset protection trusts in the United States, this doesn't rely on the fiduciary doing anything. It's just Alan creates this trust for his wife, but he gives his 3 most trusted friends, who are not beneficiaries and in a non-fiduciary capacity, a special power of appointment to appoint the property to any descendant of Alan's mother or his wife's mother. And as a consequence, that should not be subject to the claims of creditors in any state. Take a look at the commentary to section 505 of the restatement of the Uniform Trust Code, section 505 of the Uniform Trust Code, the commentary to that. It makes it clear that the fact that it could be given to the grantor by the exercise of a non-fiduciary power of appointment won't cause a creditor problem. So that's something that you can use, and it's really, I think, a great idea.
So
if you want to read about it, it's in the February 2019 issue of Estate Planning Magazine by Mitchell Gans, Abby O'Connor, and me.
So you can always buy assets out of a grantor trust. You can swap if there's a swap power, but it seems like the SPAT provision may give you another mechanism to get access, which is very important given the uncertainty, and backstop those provisions to get assets back to the settlor in order to cause estate inclusion. So again, we're trying to give you options and techniques. A lot of these are techniques that we've used for years, but in the current uncertain environment, they seem in slightly sometimes modified form, like limited powers during lifetime, not just at death, which I know some people have frequently used, but maybe now there's more of a need to build in the flexibility in light of the uncertainty. And there's some sample language from ILS on a special power of appointment there. Jonathan, you want to comment on a 2038 power, which I guess won't work if the estate tax is repealed, but may be helpful if it's not?
Well, yeah, I mean, this is an interesting idea, which really kind of Carlin McCaffrey started. Carlin said, well, if I give assets away and it turns out I'd be better off having them in the estate for the step up rather than from excluded the estate, how do I do that? And she had a formula, and I decided that maybe there was a more enhanced way to do it. This is the way it would work. Alan creates a trust, and he gives the beneficiary, normal interest in it and so on and so forth. But what he goes ahead and he does is he says that they can make the grantor, it's a discretionary trust, they can make him a trustee of the trust. And the instrument so says that if Alan created this, he's got Marty as the trustee, he's got the Bank of New York as trustee, so on and so forth. So there's no way it's going to be included in his estate, but he has said that he can be appointed as a co-trustee, a lot of discretionary power. If he had had that power from inception, it would be in his estate, but he doesn't have it, so it's not going to be in his estate. But if in fact he's made a trustee, and Alan might have the opportunity to say, no, I won't be trustee, but if Alan accepts his appointment as trustee, that will cause estate tax inclusion. So now you've kind of got the best of all possible worlds. It won't be in his estate if you don't grant him the power, but if you do grant him the power and he accepts the appointment as trustee, now it's going to be in his estate. And that's something, again, that you may want to put in your instruments just to provide that additional flexibility, which is what our presentation is all about.
Jonathan, would it be similar conceptually to that? Let's say Alan forms a DAPT in Alaska, since you love Alaska, and Alan lives in Florida, which is not a DAPT jurisdiction, correct, Alan?
Correct.
So if the trust protector, me, says we need to get these assets in Alan's estate, I'm changing situs from Alaska back to Florida. Self-settled trust doesn't work in Florida. Does that not also similarly cause estate inclusion?
Well, Marty, I'm not sure. There's a lot of authority out there. There's a case called Pialazzi. There's a revenue ruling 76-103, which basically says to cause it to come back into the estate, it has to be, the grantor has to have retained the right to control the property. In this case, Alan did not retain the capacity. It was granted to him at a later time. But it's also true, section 2038, and this is kind of nerdy stuff, but section 2038 basically says, if you've retained the power to control the beneficial enjoyment, or if when you die, you have the power to control the beneficial enjoyment, it's includable in your estate. And that would seem that even if some random event, you got that power at a later time, there's going to be a estate tax inclusion. But cases decided in the 1970s said, no, it's got to be foreseen. If just by happenstance, Alan winds up with this power, I mean, he creates the trust and 20 years later, somehow he's appointed as the trustee and he's got lots of power, that won't trigger section 2038. And section 2036A2 requires that you retain it. But that's why I say, make it explicit that you can put Alan in as a trustee. That would have been foreseeable and probably cause estate tax inclusion.
Great analysis.
Just very quickly, because I want to make sure you have time to talk about the some of the flexible beneficiaries. We should reevaluate powers of attorney. In the current environment, somebody may want to make a transfer before the estate tax is repealed of a large swath of wealth in order to get it into a GST exempt trust, because after estate tax repeal, you can't do that. Other people may be on the opposite end of this spectrum and feel that it's, the bonus exemption is likely going to be extended. I'm never going to face an estate tax. Why should I permit gift provisions? The point I'm making is powers of attorney and revocable trust should be reviewed, especially as to gift provisions. We're kind of segueing now into another realm of planning, and Jonathan, this is really something that you've advocated and developed for a while now, which is adding more flexible beneficiaries. The first one, and Alan, maybe you want to chat about adding charitable beneficiaries and how that can build in flexibility. So we're kind of going from, we talked about techniques for planning, and then we talked about techniques for adding flexibility, and now we're going to talk about techniques in this third component of more flexible, broader beneficiaries. Alan, are you able to, you want to chat about charitable beneficiaries, or would you prefer me or Jonathan do that?
Well, it's always a good idea to provide flexibility in a trust document to enable distributions to charitable entities or hybrid charitable entities like charitable remainder trusts and charitable lead annuity trusts. After discussing with the client whether they'll permit that in the document, explaining that you cannot easily get an income tax deduction equivalent under Section 642C unless it's in the original document. And then possibly having some anti-cult language so that the assets in the trust don't get taken away by an aggressive organization. But once you balance all that, and the client says, oh yeah, charity may be important, or my church or synagogue may be important, or my alma mater may be important, you can go ahead and tip the scales towards helping charity and also giving the flexibility that the family will need to do income tax planning and charitable planning going forward.
Yeah, I mean, what Alan said is important. You can always say, well, why don't we just give the property to the beneficiary and have the beneficiary go ahead and make the charitable contribution? Well, maybe the beneficiary won't do it, but also keep in mind, the beneficiary may not have the ability to deduct it all, whereas if you put in the trust a mere authorization for the trustee, even if it requires a beneficiary consent, to pay gross income from the trust to charity, you get an unlimited income tax charitable deduction. The limitations which individuals face, which is up to 60% of their income today, used to be 50, but now it's 60%. But you can go ahead and get a 100% charitable deduction in most cases if you mention it in the trust instrument. There's no downside. So if you want to have more go to charity, that's a better thing than giving it to the kid. For example, in New York, believe it or not, if you have a lot of income, as Alan and Marty do, at a certain point, they begin to take away the benefit of your charitable deduction. So that's a bad thing. You don't have to worry about that if it's in the trust. The trust, even if it's a New York trust, doesn't face that kind of limitation. So that's one of the reasons to put charity in as a potential, not mandatory, but a potential beneficiary.
In the current environment, right, very uncertain. But as Alan pointed out in the first couple of minutes of our program, some clients rightfully, and we should as advisors encourage all clients to take the long view. And we don't know that, you know, even if the bonus exemption's extended, if it's made permanent, the estate tax repealed, income tax rates lowered, whatever, who knows what's going to happen when the composition in Washington changes. So clients that are not worried about tax consequences today, or certainly estate tax consequences, may find 5 years, 10 years down the road that all these worries are there. Wouldn't it be great to have the flexibility to direct some of that money to charity and get a tax deduction or an estate tax deduction if the law changes? Don't forget, the Democrats have proposed things just very recently, and you know, maybe but for Cinnamon Mansion, those things would have gone through, where, you know, after X number of years, and it wasn't a long number of years, you know, you'd have deemed realization of appreciation in trusts. Wouldn't it be nice to have baked into that trust, not only, as Alan said, to meet the governing instrument requirements so you can get your income tax deduction, but to have the option there in case the laws change in ways we can't foresee? I almost think, and that's why I put the slide in from a presentation I did with Jonathan 5 years ago, that this constant of uncertainty may be suggesting to us that we need to just draft more flexibly all the time, because who knows what's coming down the pike next. And by the way, we and this is not in the slide presentation, I don't want to belabor it, but, you know, decanting is a great tool to try to correct or fix a trust. but there have been a number of, there was a CCA which had a very bizarre result of deeming a gift from the children as remaindermen. There have been some cases that have examined decanting, and the bottom line is you can't just rely on great power to include in the trust expressly. That may be in the outline, it should be, but you can't rely on decanting as the answer to modify anything that's gone wrong or could be updated in a trust. So including broader beneficiaries and charities as an example is really important.
Let me ask you guys a question. Alan and Marty, would you think your clients would like it if you could go to the beneficiaries and say, you know, the trust has $250,000 of income this year. How would you like it if we didn't have to pay any income tax on that?
I think that would be very popular.
That would be very good. Well, let me tell you one of the things.
Alan, I thought your clients like to pay income tax.
One of the things that you can do, and this is merely an authorization, you don't actually have to do it, is you can authorize the trustee not just to distribute distributable net income, the measure of what can be taxed from a trust to a beneficiary to individuals, but you can also have it paid to a charitable remainder trust. And any income that goes into a charitable remainder trust from an estate or from a trust is never going to be subject to income tax in that hands. That's because the charitable remainder trust is exempt from income tax. So if you have a lot of income and the family doesn't need it right away, you could put it into, say, an income-only charitable remainder uni trust. You pay it over to the trustee gets it, the trust reports it, no income tax is due because the trust is exempt from income tax. Now, at a later time, maybe 10, 15, 20 years down the line, it may be that that income will deem to come out and be taxed at that time. But getting up to 20 years of deferral on income is a pretty nice option for people. And again, especially if they're charitably inclined, you might say, well, look, we're going to put it in the charitable remainder trust. We're not going to pay any income tax. Later, maybe distributions can be made to the family. There might be some income tax at that time. But up until then, we'll just sit there. And if at the end of the day, you'd say, you know, we'd rather have it all go to charity, you can do that merely by not making distributions from the charitable remainder trust, by having an income only charitable remainder uni trust, and eventually at the end, have it all go to your favorite charity, which could be your family foundation.
Let me interject a question to both of you, and I was going to wait until after we talked about S-corps and a few other things, but let me just do it here at this juncture. What harm is there, generally speaking, integrating these array of potential beneficiaries to, and again, the charitable remainder trust is going to be for the same beneficiaries as the charities plus the beneficiaries of the trust. You're not diverting it to other human beneficiaries. What's the downside if you build in these possibilities? They don't exercise them, right?
Well, I guess, Marty, that's true. I mean, you know, how would it be is if the family goes to the trustee and says, you know, we understand that you could have paid this over to charity and we wouldn't have faced these limitations because I wasn't planning on, you know, itemizing my deductions, or I understand, you know, we could have set this aside and not pay income tax, and you had this power in the instrument, but you didn't do it. One of the reasons I like this is that the lawyer and the accountant and the family can get together every year and make a decision as to what they want to happen in this trust. And remember, one of the nice things under section 663 of the code, you've got 65 days after the close of the year. The year, if it's a trust, is almost always going to be a December 31 year. But you've got 65 days after the close of the year to decide what you want to do. So maybe you set it up for, say, the beginning of February to get everybody in the family and their advisors together when you're talking about significant amounts of money, to say, what should we do? How much should the family get? Because we can make this distribution, you know, up until March 4th and pretend, and the court explicitly says you can pretend as though it was distributed in the prior year when that income was earned. So that's, again, something else, but it's going to put the burden on you and then the accountant and the trust officer, everyone, to meet with the family to go over this, to explain what options they have and really try to save money and do what the family wants.
But if you don't have the provisions there, you can't do it.
That's right.
So isn't this kind of like, why not put it in, give the flexibility, especially since we have no idea where anything in the world is going?
I think it's a great idea, Marty.
Absolutely.
Do you think anyone has appreciated securities any longer to, no, I didn't ask that.
Well, the market has been down a little bit.
Little bit. Jonathan, this was your idea, and I think you should explain it. But in the context of creating flexibility, this is a fascinating idea to think about integrating into a trust.
Well, one of the other things, and I've got language which we can share with anybody who wants it. It's not copyrighted or anything else, to put in how the trustee can distribute. And let me just mention a couple of things, and some of these are going to see, I'd never do that in a million years. Not just allow distributions to descendants, but spouses of descendants. Why? I don't want my daughter-in-law or my grandson-in-law coming after it. Well, number one, that person is only an eligible beneficiary while he or she is married to or living with a descendant of yours. But one of the things that can be done, let's say one of the descendants is under the threat of a creditor. Well, you don't want to give her the money because the creditor will take it. So that's one of the reasons. Number two, maybe you have descendants, and I've had them, who are terrible spendthrifts. I've had 2 clients who's had children who died because they failed to pay gambling debts. These are very, very wealthy families. The kids were absolutely out of control. And eventually, believe it or not, both of them, entirely different families, different coasts, died. But if anything had gone to them, it would have immediately gone up their nose. So as a consequence, you can give it to the spouse who can expend it for the family. You may want that flexibility. You don't have to use it, but it's there if you need it. That's one of the things you want to do. It sounds like a crazy idea. And in fact, clients going, why did you put my son-in-law in here? I don't even like him. Well, it's because it's for the benefit of your daughter, really, at the end of the day. And again, you can have adults who are the only ones who can make that decision. In addition, this is a crazy thought. Suppose I say, well, you can pay it over to a corporation. What? I've never seen a trust where the beneficiaries, unless it was a charitable trust, where you could say you could pay it to a corporation. But maybe you want to do that. One of the things is the DNI will be paid to the corporation, and maybe the corporation is in a lower tax bracket than the individuals would be who are the shareholders. In addition, you could even make it an S corporation. And even better than that, perhaps you can pay it over to an S corporation of which has qualified subchapter S trusts as part of its makeup. And that will provide great opportunity because let's say you have a family where not everybody is as rich as Alan and Marty are, and these people are in relatively low brackets, but you don't want to give them the money. You don't want to give them the money because maybe they'd lose government benefits. So what you do is you pay it over to the S Corp. The S Corp in turns income. It's now got the income from the trust. The S Corp reports it. But if it's a qualified subchapter S trust, that income isn't taxed to the trust. It's taxed to the shareholder, and the shareholder here will be a qualified subchapter S trust. But it's going to be taxed at the beneficiary's tax bracket. So you have a trust which is for the benefit, say, of Sean, and Sean's got very low income. Maybe he's entitled to government benefits, but you don't want to give him the money because he'd be disqualified. Well, you're not going to give him the money. You're going to give it to a qualified subchapter S corporation, and that's going to be taxed to the qualified subchapter S trust, but at the beneficiary's rates. So it gives you a great opportunity to do very good income tax planning without losing government benefits.
And while this sounds complicated, the component parts are basic component parts that everybody's worked with. Creating an S Corp, I mean, there's millions of S Corps out there, not that difficult to do. Creating a qualified, a QIST, qualified subchapter S trust with document generation software is not that big of a deal to do. For a fairly modest cost, you can create a structure that gives you unfettered control over where the cash is and that you can send the tax benefit down to the beneficiary. Again, the idea, this whole third or fourth segment that we're in now, is trying to expand what is typically or traditionally done in terms of beneficiaries to broaden it, to create another mechanism of having flexibility in irrevocable trusts, given the incredible uncertainty that we face now. This next section is fairly simple and fairly obvious, but I do want to take a second, and Alan, you, Jonathan, can jump in, but just to make the general point. With estate tax rules so incredibly uncertain, clients may say, golly, I get it that I should put everything in a GST perpetual trust, because if they repeal the estate tax, I may not be able to do it. And if the Democrats take control at some future date in Washington, I don't want to go through this again. I'd rather see if I can get grandfathered. I understand it's not guaranteed, but it makes sense to me. I would do it. But one of the things that I think changes given the uncertainty is right now, short term, it looks like there's no way we're having any increase in estate tax. The bonus exemption may get extended and may be made permanent. The estate tax may be repealed. I think to get clients comfortable planning for the longer term, as we've talked, they need more access to the money that's in these trusts. And I think the sort of easy answer of, oh, I'll do a SLAT if it's a married client, is a nice starting point. But DAPTs, hybrid DAPTs, SPATs, lots of other options to integrate more access into a trust. Alan, you want to just comment on that? Because I think a lot of practitioners don't really put, they go with a more plain vanilla SLAT instead of expanding it for access. And I think now clients are going to want that. And especially if they're going to make a large transfer, it may make a lot of sense.
Well, for all the flexibility we've been discussing, Marty, it can all come together when the client sets up the irrevocable trust. And if they want to put that trust in an asset protection jurisdiction and have the grantor be a potential beneficiary of the trust, that seems pretty safe if the grantor resides in an asset protection jurisdiction. But for those of us who don't reside in an asset protection jurisdiction, if I want to set up that kind of trust and I want to be a discretionary beneficiary of the trust, I have to worry about whether Florida law is going to apply or Alaska law is going to apply. And I've got to worry about, do I really need a benefit out of this trust? Should I give the trustee that ability? And if I give the trustee that ability, should I have a way that the trustee can take that ability away from themselves, or the trust protectors can take that ability away from the trustee a little bit more than 3 years before I die, so I don't have to worry about whether Section 2036A applies? So, when we talk to clients about doing dynasty trusts and we tell them you could do the dynasty trust in an asset protection jurisdiction, it might come back to you if an act of independent significance occurs, such as you unexpectedly become destitute. It's just one more thing to think about, and one more decision that a client can make. If all of these decisions don't break the camel's back, by the way, because we've discussed a lot of things here.
Well, Alan, one of this shows is, tax planning and other planning is complicated. There's always going to be a role for really informed estate planners. I mean, it's just an unlimited number of things. So, you're doing right, I think, by your clients by putting them in a position where they can take advantage of so many of these things, not just for asset protection and not just for taxes, but for all the other things that happen in life, things in the family and so on and so forth. And you're really the pilot in command on this. You, the lawyer, the estate planner, and you've got to make sure your clients appreciate that and come back to you at least once a year to discuss what's going on.
By the way, I'm gonna throw in a plug for document generation software. I still know practitioners that have, a small handful of forms that they draft from, and I don't know how you integrate all the decisions that we've been talking about in this program. If you have like a prefix menu at a restaurant form, with document generation, you literally just go through the template of the questions and you can make decisions on all the different decision nodes that we've talked about. And it's been if we put them all together in a like a decision tree, it's a pretty big decision tree with all the options that we've talked about. But simply by checking the boxes that work for a client in about the same amount of time, which is fairly modest, you can create an incredible array of very different trusts that fit each client's temperament, risk profile, worries about access versus not, and so on. All these special beneficiaries that we talked about sound quite complex, but literally in document generation software, it's checking a button saying to add this provision that gives you the ability to add all those beneficiaries. It's very practical to do. And I think at the time, this inflection point of incredible uncertainty that we're at now, that's at least what we should be offering clients and maybe even giving to clients where they're comfortable with it. I think we're getting near the end. One of the other things, and Alan, maybe just comment quickly, but all the other aspects of planning that somehow get left in the sauce, in the dust rather, like asset protection and divorce protection. You just make a few comments because to complete our discussion on why this is all so important.
If we only had 20 hours to spend with each client, we could take everything that could become the most important thing in their estate plan. But the nice thing about losing the federal estate tax, if we lose the federal estate tax, will be more time and more attention to what's really important to the client, which I have found is creditor protection and divorce protection and protection of my children and things like that. So, it's really hard sometimes to get a client to think about all those things, because when you try to do that, you get nothing. All you've done is scare the client away. But the creditor protection goes so well hand in hand with the estate tax protection. And that, coupled with the fact that there's a great chance the estate tax is coming back, even if it were to go away, has led me to believe that planning will not change as much as you would think.
I think that's a really critical statement, and I wholeheartedly agree. So I think the estate tax, even if it's repealed, is coming back in some form, shape, or manner, and probably much harsher than it is today. And we may have a wealth tax, we may have both. And lawsuits and the threat of lawsuits and the threat of divorce are not going to dissipate. So if a client needs a motivation to plan, it's the asset protection. And hey, by the way, it may make sense from an estate tax perspective, and we're going to throw in some extra mechanisms for flexibility because of the uncertainty. That kind of, to me, sums it up. I think we're getting near the end of the time. Jonathan, you want to take a minute or two and make any comments, thoughts, suggestions that you have?
No, I thought what Alan just said is spot on.
And you haven't seen this kind of uncertainty before, or have you? That's the best answer.
Well, Marty, George W. Bush ran on a platform where he said his #1 domestic agenda was the repeal of the estate tax. And of course, he was elected, and I thought, well, now the estate tax is going to be repealed. The estate tax was not repealed. It was out for a year, but then you had to basically accept no step up in basis. Now, there are proposals in Washington basically to eliminate all taxes. There are even proposals to eliminate the income tax. I don't think that's going to happen. I think that, by the way, this is interesting. Of all the top 80 countries in the world, no matter how you do them by size, gross domestic product, whatever it is, the United States is #2 on the little part of its gross domestic product that it gets in taxes. We take less than virtually every other country, less than Russia takes, less than China takes, France, Mexico, Uruguay, Panama, everywhere. The only country that spends less, takes less of its gross domestic product for taxes than we do is Chile. And that's because they have great natural resources and they use that for funding their government adventures. But we, I know, all feel that we're just killed by taxes, but here in the United States, we actually pay a lower tax. So there's a lot of room to move up. Now, right now, I think in Washington, there's a proposal, let's get rid of taxes. But if you get rid of taxes, as we've heard recently, you get rid of services. And some of those services, I think, to many of us are very, very important for ourselves, for the country, and for our families.
Alan, any parting words of wisdom?
Well, every time I do anything with you guys, I learn a lot, and I have to go back and do a lot of reading. So I just want to thank you, that Marty, you did a great job on this PowerPoint, and Jonathan's thinking, is just immense. There's a lot of choices that we all have, and it's just time to have the rubber meet the road. As a practitioner, make your decision on what you're going to offer your clients. Get some help if you need to get some help, and go out there and we do the very best we can every day with the clients and the challenges that we're blessed to have. But thank you very much, both of you, for making this world a better world for professionals and for the clients we have.
Alan, thank you for having us on the program. It was really a lot of fun and very, enlightening, really. Thank you.
I think we have a wonderful opportunity to continue serving clients. And the fact that it looks like there's proposals for repeal or proposals to extend the bonus exemption doesn't negate the value that we can add. I feel one of the biggest worries is not the technical hurdles, which are immense. There's a lot of issues, a lot of techniques, a lot of thoughts out there. But it's what Alan pointed to earlier, is if you actually sit down and tell a client every single thing that we just talked about, I think the client's going to glaze over and be overwhelmed. So that, how we implement it, what we offer and how we do it, I think is part of the art of what we need to do. And I think one of the ways that may be easier to do is in a team approach where other advisors are echoing some of the same points that we are. So thank you, Alan, for putting this on. Jonathan, thank you for your insights as usual. And thank you all for joining us.
Have a great day.